we will focus on indigenous rights struggles. And of course, as most of you know, this comes with sadness, because this year's annual lecturer was not able to join us due to arbitrary and racist treatment by airline staff, preventing her from accessing the plane. But what we do have is a full day of really, really interesting roundtables, discussions, and a documentary featuring this year's annual lecturer, and we will have a roundtable afterwards that will sort of discuss a lot of what she would also have introduced tomorrow. But then to this year's keynote speaker on indigenous rights. And of course, most of you would know Rachel Cedar. She's a professor at CIESAS in Mexico, the Center for Research on and Graduate Studies on Social Anthropology in Mexico City. And she's also been, for a decade at least, affiliate researcher at the Christian Michelsen Institute in Bergen. And she's one of the world-leading experts on indigenous rights struggles and a lot of other issues. She just came out with a book that she's edited with some colleagues, and a lot involving some of you, I think, but at least a lot of researchers on law and society in Latin America. So this is the big and important volume on law and society in Latin America. It's really an amazing achievement. So today she will talk about the juridification of indigenous politics, and then that will be followed by a roundtable chaired by Namita Wahi.
Work. Can you hear me? Yes, great. Well, good morning, everybody, and thank you, Siri, for the introduction. I'm also really angry and sorry that Irma Alicia Velasquez can't be with us, and unfortunately, it's a salutary reminder of the stuff that Indigenous peoples and peoples of colour have to put up with every day, that we really need to think about every day in the academe in terms of what we do. Thank you also to CMI for the invitation to kick off today. I know it's going to be a good day. I'm really looking forward to it, and it's great to be back among colleagues and doing what CMI does very well, which is get us all to talk to each other across disciplines and across interests. So, as you all know, during the last decades of the 20th century, Indigenous peoples the world over became collective subjects of international law, which gave them specific and differential rights to territory and to autonomous governance, or in the language of the UN Declaration on the Rights of Indigenous People, which was so fought over for so many years, rights to self-determination. And in this way, Indigenous peoples' justice claims came to be encoded in the language of human rights. There we have that famous assembly when it was approved. In a few countries, the special status of native indigenous populations was already legally recognized by the state to some degrees, and in others it wasn't. But this international legal transformation really constituted a global paradigm shift. And as we know, it transformed domestic and particularly constitutional law in a vast range of contexts, and particularly, though not exclusively, in Latin America. And that transformation was driven by the ongoing efforts of indigenous peoples themselves to defend their ways of life in the face of what are ever-growing threats to their existence, material threats to their continued existence. So when we study juridification and judicialization, we do a lot of work on indigenous peoples because they're one of the strong cases. They've resorted to national, international judicial arenas to fight legal encroachments and illegal encroachments on their lands, on their ways of life, and against the multiple forms of racialized violence and criminalization that they increasingly face, that they have always faced, but we're in a particularly tough phase at the moment. Those engagements with law, through law, are of course, inextricably tied up with processes of identity formation and transformation. And this category, this legal category from the late 20th century of indigeneity, now links a hugely diverse range of peoples across borders and continents. So these processes of rights claiming and transformations of identity that occur through different kinds of engagement with law can broadly be understood as juridification. And I want to talk here about the juridification of indigenous politics and suggest that the legal mobilization around indigenous peoples' collective rights claims is fundamentally different in very important ways from processes of juridification of politics more generally. So that's kind of my one big point for the lecture, which hopefully will make sense by the time I get halfway through. So juridification, what is it? Can involve judicialization, which is the displacement of political battles to the courts, but it's a much broader phenomena than judicialization, which we've all been studying for many years. The concept's been understood as a form of legal framing, whereby through the process of claiming rights, people come to see themselves as legal subjects, so there's a large literature on that. It also is used to refer to legal or law-like ordering, wherein courts or other agents, such as NGOs or international organizations, transform forms of political organization by demanding certain kinds of legal legibility from them, right? Anyone who's ever worked in an NGO here and had to do reporting knows that you become a legal subject through these processes of accounting and legibility. So that's one dimension of it too. And whereas most processes of judicialization, for the most part, they occur in domestic courts, the global legal pluralism, this overlapping, multi-scalar nature of global legal pluralism, is a defining feature of all contemporary forms of juridification. And we all know that we study the ways that contract law is enforced and where it's enforced outside of the countries where often the mines or dams or whatever we're talking about are actually taking place, and of course the work that we know from claiming of for gross human rights violations, the way that that occurs often simultaneously in domestic, regional, international courts. Broadly, I think we can identify two main perspectives on the phenomena of juridification, and I think maybe they're best kind of seen as extremes on a spectrum. So the one side, you've got the Komarov's view, if I can shorthand it with them, to say, well, juridification is insidious, it's a form of domination via the jural, it's a hegemonic form of standardization. They argue in that famous article of theirs that law is a bit like money, that it converts the incommensurable into the commensurable, and that is a step in facilitating capitalist dispossession across borders. So, and there are a lot of there's a lot of work in that vein that looks at kind of the way in which complex global legal pluralism fragments and facilitates that kind of processes of disempowerment and dispossession. I really like Shalini Randeria's work, for example, and she looks at how you have an expansion and superimposition of different legal and quasi-legal forms, so arbitration, mediation, inspection, at lots of different scales and levels that now make up the composite of what we understand as development, and how ultimately that's quite disempowering for the subjects of development. So that would be kind of one end on the spectrum of interpretation that says this turn to law really privileges technocratic knowledge, elite forms of knowledge, it fragments political battles, it depoliticizes, and ultimately it narrows the space for collective action. And then at the other end of the scale, while they still maintain a very critical perspective on law, different authors, and particularly from Latin America, have looked at the counter-hegemonic possibilities of using law. And in their famous book, which is now, nearly 15 years old, Cesar Rodriguez Garavito and Boa Santos used this term, legal globalization from below, which of course has been so taken up. So recognizing the growing importance of legal struggles and rights frames for political activism at the same time that they're not ditching a critical perspective on law. So I think those two readings aren't mutually exclusive. And obviously, as an anthropologist, I would say to you the impacts of juridification and politics and collective action we can only ever understand in context. Julia Eckert and her colleagues have argued that really we need to think about juridification as a very wide range of social processes through which law is socially constituted, right? And it's generally characterized by processes of norm diffusion, adaptation, vernacularization, and that the outcomes are uncertain and contingent, right? That we can't second guess that to start with. Okay. Anthropologists have long explored how engagement with different facets of law shapes individual and collective identities, and they've documented how these juridified battles transform people's perceptions of themselves, often forging new group identities where those previously didn't exist. And there's been really a wealth of wonderful literature on the juridification of indigenous politics in recent years. As I said, while indigenous mobilization's always deeply rooted in specific places and specific ontologies, what Arturo Escobar has termed place-based struggles, at the same time, entanglements with law have generated this broader epistemic community which has cemented a transnational identity of indigenous peoples. And engaging in legal battles and strategic litigation is a really central part today of indigenous peoples' politics the world over. Thinking of recent work, for example, on the San people in Botswana by Maria Sapignoli, she says, and I quote her, litigation has become one of the strategic anchorages of the global indigenous movement. Now, then there's a literature that kind of looks at the way in which encoding all these vastly different subjects as this category of indigenous peoples might have encouraged certain kinds of strategic essentialization, using that term, or demanding the performance of established scripts of indigeneity, thinking of Povinelli's work on Australia there. But really the point is that the prevailing international norms of self-determination emphasize self-identification and the right to self-definition. And those are arguments that indigenous peoples have mobilized against states which charge that they're not really indigenous people, that they're somehow inauthentic because they don't measure up to scripts or standards generally devised by non-indigenous people. And a lot of the broader debate about the juridification of politics, more broadly, tends to refer to the diffusion and the vernacularization of state law and international law, and the kind of identities and discourses and collective action that are generated by engagements with dominant norms and dominant institutions. And what I want to argue here is that I think processes of juridification that involve indigeneity, indigenous peoples, are both empirically but also conceptually different from juridification of political or moral claims per se. Why? Well, that's because although you have had the vernacularization of hegemonic law and the associated transformations of identity and subjectivities in evidence, right, this transnational category of indigeneity and how that transforms people's self. But what's ultimately at stake is the battle for the existence and the legibility of different legal orders, right? Rather than just a search for recognition within state law or international law. In the initial stages of colonial expansion in certain regions of the world, indigenous people were legally recognized as sovereign, with their own forms of organization and law and jurisdiction. So the founding treaties of countries like Canada, Chile, and New Zealand emphasized the inherent sovereignty of indigenous native peoples, although those processes were always partial, and they were, as we know, sometimes completely overturned and reneged on. So I think importantly, juridification that involves indigenous peoples is in one sense about disputes between different forms of legal rationality. Native peoples' law existed as law before it came into contact with colonial legal epistemologies that, as we know, are grounded in the racialization and inferiorization of indigenous peoples. So it's those foundational inequalities of power and ongoing histories of colonization that distinguish, I think, the juridification of indigenous politics from juridified battles where plaintiffs implicitly submit to the authority of the law to adjudicate. They recognize state sovereignty. So if we thought about sexual reproductive rights, right, which have become so juridified in recent decades, with those both favoring, expanding, defending women or defending women's right to autonomy over their bodies, and those that oppose those policies, they both camps resort to legal framings and litigation. And we've seen in recent years, and the work that you've all been doing at CMI here, of course, points to the way that those discourses of moral, religious discourses have increasingly been replaced by legal discourses in this field, by rights discourses, both sides of the divide invoking rights. And I think by contrast, while contemporary juridification that involves indigenous peoples does, of course, hinge in part on the vernacularization of rights frames, those human rights frames don't replace the different ontologies that underpin the alternative legal orders that are defended by indigenous peoples. And they don't pose the kind of challenges to hegemonic frames of legality that indigenous peoples' law often does. So I think the literature underestimates this dimension, right? A lot of the literature on the juridification of indigenous politics points to subjects becoming enmeshed in ever more inescapable webs of law, increasingly internalizing dominant legal cultures. I'm thinking of maybe Ron Neisen's work, where he argues that, I'm going to quote him, he says, international human rights law has generated a body of rights-oriented knowledge that includes an understanding of the essence of humanity and the legitimate forms and categories of human belonging, something that he talks about as a strategic epistemology that reinterprets common understandings of human life and therefore redefines human identity. So human rights law ends up narrowing the possible constructions of the human. And in my view, such readings place far too much emphasis on top-down processes of norm diffusion and the vernacularization of hegemonic forms of law. And I think in particular, they pay insufficient attention to the law of indigenous peoples themselves and to the ways in which autochthonous norms and practices of governance tend to circulate through more horizontal forms of knowledge transfer and exchange between indigenous peoples and their allies, and that those processes are involve very complex processes of interpretation and reinterpretation that shape collective identities, but also political futures. And so that's kind of where I'm trying to intersect with the literature on juridification of politics. So, juridification involving indigenous peoples then is much more than the use of state law or international human rights law against the state in pursuit of recognition, greater distributive justice, but it also includes the mobilization and reframing of alternative legal and political orders that are aimed at ensuring the continuity of indigenous peoples themselves, and actually, I would argue, often aimed at ensuring the survival of all of us and the planet. The interesting thing that I've been privileged to witness in my work over the years is the way in which the recognition of legal pluralism in Latin America's constitutions, even though it's been limited, it's been ambiguous, it's been begrudging, but it's there. And it has meant that lawyers who defend indigenous peoples' collective rights to territory, autonomy, land, and so the lawyers and the judges who adjudicate those cases, they've had to engage with different alternative conceptions of what law is. Right? That there's not just one form of law and how we engage with that. I think the implicit, or it's sometimes explicit, sometimes an implicit challenge to hegemonic forms of law that is contained in the indigenous juridification of politics, signals what Audra Simpson has termed indigenous refusal, right? And that's a body of literature debates about refusal of the terms of late 20th century multicultural recognition, which some of you probably will know. So through these juridified political engagements, Native peoples, I think, lay bare the racialized frames and categories that have systematically stripped them of their territories in legally sanctioned forms of genocide, which have gone on for centuries. And the political insistence on indigenous law, on indigenous jurisdiction and sovereignty is a counter. It's a counter to colonial erasure, and it challenges in important and complex ways the jurisdictional claims and the temporalities and the ontologies of state law and international human rights law. So the juridification of indigenous politics then is a political claim for epistemologies and ontologies of law that ultimately they may be grounded in understandings of personhood, of time, of space, that may not be commensurable with dominant forms of law, right? So they're kind of counter to some of the earlier vernacularization literature, which sort of assumes that we're all going along a continuum and that ultimately there's convergence. And I like very much the work of scholar Mark Rifkind, and I'm going to cite him. He says, he's talking about the idea of refusing frames of multicultural recognition. He says, the idea of refusing recognition is less about being unimplicated in the choices, affects, policies, imaginaries, and brutalities of non-natives than it is about insisting that indigenous people have an existence that is not a priori tethered to settler norms and frames, right? So that separation, right? The ontological difference in forms of law and being. Okay, if you have contexts like the one I work in Guatemala, where a lot of the dominant legal order is seen by indigenous subjects and indeed a lot of the population as being illegitimate imposition, and subjects might posit radically different understandings of governance and law and morality, then what happens in juridification? What kind of processes of subjectivization and politics are generated? And through my own ethnographic work, I explore these issues by looking at the dynamics of the juridification of Mayan law in post-war Guatemala. And over the years, I've traced the different ways in which Mayan rights activists and their allies have revitalized, analyzed, reflected on, defended their own forms of law in this broader context of battles for state recognition of legal pluralism in the post-war period. And the rest of what I'm going to say, I'm not sure how I'm doing on time. I did bring my phone up here and then I didn't turn it on. 20 minutes. Okay, 10 minutes. In the last 10 minutes, then I'm going to talk a little bit about that. And I also, if I have time, want to reflect a bit on the responsibilities and the challenges for us as academics, because we're also implicated in these processes of juridification ourselves. So while the organization and the laws of Mayan peoples date back thousands of years, the self-conscious political use of this term Mayan law emerged in the immediate post-war period in Guatemala following the signing of the peace accords in 1996 that brought an end to 36 years of armed conflict. The 1995 Accord on the Rights and Identity of Indigenous Peoples, one of the peace agreements, was committed the state to recognize legal pluralism and approve legislative reforms that were going to guarantee the rights of Indigenous peoples to use their own forms of law to administer their affairs, so their customary norms, as it was talked about in the agreement. There was very weak recognition of territorial autonomy and of ancestral lands in those agreements, but in the years subsequent to the peace settlement, Indigenous mobilization to defend territory and to claim greater self-determination has increased in direct response to the threats to indigenous livelihoods that, like the rest of Latin America, are posed by mega projects, material poverty, and particularly in Central America, the multiple and increasingly acute effects of climate change on rural peoples. And in the final years of the armed conflict, you had an awful lot of different Mayan rights organizations and NGOs across the country allying with academics, NGOs, international development cooperation agencies, trying to systematize what came to be termed Mayan law, this umbrella term. And interestingly, at the same time, all of those activists said, we don't want to codify Indigenous law, right? We've read the history of attempts at codification of native laws in other parts of the world, and we know the inherently colonial premises of that undertaking. But what they lobbied for was constitutional recognition of Indigenous jurisdiction, and they insisted on their rights to define their own forms of law. So it was a conscious positioning of Indigenous law vis-a-vis state legality in a bid to build a more pluricultural legal system, but not only about that. It was, I think, more importantly, a grassroots movement across the country which was trying to revitalize and reaffirm forms of community governance and identity in the wake of the armed conflict, which had taken such a tremendous toll on Indigenous lives and culture. So Mayan law was a form of praxis then, whereby Indigenous and non-Indigenous intellectuals and communal authorities at many different levels reflected on and tried to systematize their own governance practices, right? And what were their underlying moral, philosophical, and historical roots. Yes, they were about claim-making before the state, but they were more broadly about reconstituting collective identities after genocidal violence of the armed conflict. And they were very much about the continuity of Indigenous life worlds. So in other words, I think the reorganization of what came to be termed, at least for the outside world, Mayan law, was more than anything an inward-looking process. And it was about reconstituting self and about thinking of forms of justice that went way beyond multicultural recognition or post-conflict reconstruction or any of the frames it was set in. And there are a number of emblematic examples of Mayan law, particularly Maya Quiché law. There are 21 different Mayan groups in Guatemala, but the systematization of some forms of law have kind of become more prominent, dominated more in some of these conversations. So you have communal leaders championing their own forms of law, and that happens beyond their immediate locality. So it underlines the kind of political processes and this horizontal exchanges that I'm talking about. For example, in Santa Cruz del Quiché, which is one of the places I've worked for a number of years, it's the municipal capital of the Department of Quiché. There's a supra-communal indigenous mayoralty. It's reconstituted by local Mayan leaders in 2003. And it subsequently gained prominence and a lot of controversy for its defense of the application of what they define as Maya Quiché law. And that includes the use of chicay, which are ritual beatings, cleansings with the branches of quinch tree that the local Quiché authorities explain are intended to correct the energies of those who are processed for the transgression of community norms. And there are other processes that are used to recover shame, which include shuklem, which is where the penitents process anti-clockwise around a circle 3 times on their knees in order to ask pardon from the earth. And these are hugely controversial practices for the human rights community, as you can imagine, not just for the human rights community, but they're the ones that I argue most with. And the authorities in Santa Cruz defend chicay and shuklem, and they really refuse to domesticate their own legal practices to cater to the demands of those who would not recognize indigenous law anyway, but also those who would domesticate their forms of law. So they, I think, by doing that, inherently challenge the ontological premises of hegemonic forms of law, and they refuse to reinscribe the power of hegemonic forms of law by those forms of resistance and refusal. And what state actors, some elements of the international human rights community would argue is corporal punishment, in the worst forms torture, is defended locally as alternative frames for justice, redress, and reparations. It doesn't mean that there's not debate about those practices locally. There is. It's constant and ongoing. But the terms of that debate are quite different from the ways in which it's delegitimized in more national debates which are framed by the terms of hegemonic human rights law. So the continuity and defense of Mayan law, therefore, I think, critically interrogates colonial histories by challenging the very legitimacy of dominant forms of law. And it instantiates alternative conceptions of sovereignty, similar to what Justin Richland in his work on Hopi legality has described as sovereign time. Sovereign time being narrations of indigenous law and norms of governance that are grounded in tradition and that establish juridical authority. They function as part of the legitimizing backdrop to contemporary indigenous political and legal action. And that, to me, is the fundamental point. Rather than which configuration of domestic and international legal arrangements might best protect indigenous people in specific contexts, that's very important, and we do a lot of work on that. But I think the point about different legalities often gets erased in those discussions. Okay, I have 5 minutes left, and I just want to say something about what we do in all of this. As I said, the juridification of politics involves multiple processes within and beyond the courts, and diverse research collaborations are a central part of this process of juridification of Mayan law, and they're often riven with tensions about different understandings of what law itself is, different perspectives on how it should be studied and approached, by whom, and to what ends. And I keep coming back to one particular incident that happened to me around how to conceptualize and depict Indigenous law. I was at a forum hosted by the Soros Foundation about 8 years ago in Guatemala City on interlegal, intercultural coordination. We have done many of these kind of forums over the years in a lot of Latin America. And I was really stung by the criticism from a Mayan intellectual who was really unhappy with the depiction of Maya Quiche law in our documentary, the documentary I made with Carlos Flores, which is called Quixpal, Shame. It's about 3 youngsters who are processed for the stealing of a truck in Santa Cruz of Quiche. And we made it in collaboration with the indigenous mayoralty in Santa Cruz of Quiche, and it includes footage like this, which was shot by the villagers themselves. So we didn't shoot the whole thing. They gave us their footage, and we did. We worked a long time on the guion, the script, and the editing, and we went backwards and forwards. So it was very consultative process, and it includes interviews with the key protagonists who explain the nature and logic of their processes of dispute resolution. But it includes footage of the Shikai. And this particular colleague, this Mayan intellectual at the Soros Foundation meeting, said to me, your documentary shows Mayan law as it is and not as it should be. And so he was challenging the representational practices that, of course, tend to characterize ethnographic approaches. And also he was challenging the kind of authority that often comes with those kind of ethnographic accounts. And so he argued, quite rightly, that state law is normally judged by its declared ideals, and Indigenous law is dismissed as a violation of human rights or due process on the basis of its perceived practice. And he insisted on the need to counterpose the philosophical and ontological bases of Indigenous legal norms to state norms. And he basically was saying ethnographic observation is insufficient as a means of approximating alternative forms of legality. And I was upset, and I, at the time, read his critique as a kind of appeal to a form of strategic essentializing or an atemporal representation of law that I was really struggling to engage with in some of the conversations. And over the subsequent years, I've kind of come back again and again to that encounter to reflect on the enormous complexities of representing Indigenous law, and also on the role that we as non-Indigenous intellectuals play in its juridification, with all of the responsibilities and risks that that entails. So in subsequent years in my work elaborating special witness reports for key legal cases defending Indigenous people's rights to jurisdictional autonomy in Guatemala, I've engaged in attempts to try and make Indigenous law comprehensible, legible, credible to judges, to prosecutors, to public defenders. And of course, those attempts by anthropologists to mediate between people's theorizations of their own forms of law and dominant legal frames are far from simple. And that's because the epistemological bases of both forms of law are often radically different, and the ability of the ethnographer to apprehend and communicate the ontologies of Indigenous law is inevitably constrained by our hegemonic legal frames and our own subjectivities. So, in conclusion, I've tried to suggest here that while these inexorable logics of hegemonic forms of law are certainly inescapable, that doesn't necessarily imply either the weakening of collective action and depoliticization, nor does it imply the colonization of other life worlds by globally dominant legalities. And in particular, I've tried to argue, I don't know if I've convinced you, but that the juridification of politics engaged in by Indigenous peoples is different from the juridification of politics per se. And I think that's a conversation we'll carry on having around gender also throughout the day in the next panel. Why is it different? It's because the claims for recognition or inclusion that broadly accept the epistemological bases of state law are different from Indigenous juridification, which is something which occurs at the intersection between different forms of law that often have radically different bases, ontological bases. That is state law, international law, and autochthonous forms of law of colonized people. So it's a platform. That encounter is a platform on which broader claims about indigenous autonomy and sovereignty and jurisdiction and territory are played out. And so this constant re-elaboration, exercise, circulation of Mayan law that I look at in more detail in Guatemala, it's a form of politics. It's an enunciation of legal philosophy, and it's also a guide to ways of being and conducting oneself in the universe. And while Mayan people certainly do use the language of human rights to claim and defend their core interests, their identities are not determined solely by the epistemologies of human rights law. Mark Goodale has called our attention to all of the dangers inherent in these relations between indigeneity, international law, and the kind of potentials for economic exploitation that are in there. And clearly, of course, law continues to be one of the principal tools of colonial and neo-colonial dispossession. But I've tried to point here to the potentialities inherent in the judicialization of Mayan law and other forms of indigenous law and governance, arguing that those different legal engagements can be read as exchanges that also contain and transmit a politics of indigenous refusal. Of course, it's utopian to expect that those dynamics alone are going to halt or even slow the onslaught of global capitalism in this current historical moment. But that doesn't detract from their importance, which does go beyond the merely symbolic. And lastly, I've really tried and not managed to continue that conversation, but I hope we will have that conversation to try and reflect on the challenges for us as anthropologists, social scientists involved in these juridification instances. And I'm advocating forms of knowledge production that are grounded in critical engagement that furthers an intercultural epistemological dialogue aimed at radically transforming those racialized structures of dispossession in which we are all enmeshed. Thank you.
So if you just lean in a bit and speak. Yeah. No, you don't have to. Hey? Yeah. So whenever you start speaking, it's on now, okay? So I have to hold my ear in my hand. Yeah.
Is the first all-women family?
Yes. Good morning, everyone. It's so wonderful to be back here for the Bergen Exchanges. To introduce myself, I'm Namita Wahi. I work at the Center for Policy Research in New Delhi, and I want to start by thanking Siri, Lara, and all the other researchers and wonderful volunteers that have put together this program. Thank you, Rachel. That was such a rich and fascinating account of the struggles and challenges of indigenous groups and how important it is to represent their voices truly in the way these struggles and challenges unfold. And, as Anna pointed out, we are the first all-women panel. And it is, I think, the first all-women panel that I've been on which is not talking about women's rights. So, so that's wonderful as well. And, Rachel mentioned that she wanted us not to respond necessarily to the questions that she raised, but rather to raise the questions that we have found in our own experiences. But I must say that, you covered almost everything that I wanted to talk about. And so to pick up on so many of the wonderful, issues that you highlighted, So the first thing that sort of came out from the discussion is the hegemonic force of law. But I want to expand that to not just the force of law, but also rather hegemonic forces of development, of global capital, and of also things like hegemonic forces of representation, both politically and socially, as well as how identity is understood. Because on each of these categories, there is a sort of hegemonic mainstream narrative, and there is then the indigenous narrative. And so what we find then is, and it was striking how much of what you said resonated with my own experience of working on indigenous people's rights in India. For instance, just to put it out there, India is a big country, 1.26 billion people. 13% of India's geographical area is inhabited or demarcated specifically for indigenous groups, and 8.6% of India's population is called the scheduled tribes. Now, the term tribe itself is a colonial legacy. It has a certain pejorative connotation, but that is the term that is there in the constitution. So even in terms of language, which is so central to identity, also we find that there is a certain way of categorizing these groups and so on. And so, I mean, I think what really came out is the fact that there are all these hegemonic forces against which the indigenous groups are pitted, but also in terms of discourse, and you talked about law and rights, and that is one form and one dominant discourse. But in developing countries like India and many of the countries that panelists come from, it is now my pleasure to introduce all the wonderful panelists. So starting from the extreme right, we have Ana Briconnier, who is a PhD candidate in the Latin American Studies program at the University of Texas, and is studying judicial decision-making at the Constitutional Court in Guatemala on cases related to the right of indigenous people to free, prior, and informed consultation and consent. And then we have Akansha. Akansha Jain is from India. She's also working at the Center for Policy Research at the Land Rights Initiative. Akansha is a social science researcher working on land and indigenous people's rights, and holds a master's in development studies from Ambedkar University in New Delhi. Then we have Natalia. Natalia is from Colombia. She's also a PhD candidate at the University of Texas, but in government. And before starting her PhD, she has actually had considerable experience working on, the legal mobilization strategies that have been deployed for these rights from both the community perspective, but also from the perspective of the court. And she will be sharing her valuable experience with us. And she has been particularly interested in the strategies and struggles of between indigenous people's leaders on the one hand and the CEOs of extractive companies on the other, around the content and procedure of the right to consultation. And finally, we have Angela Lind, who is a PhD candidate in social anthropology at the University of Bern. And her research also focuses on social conflicts in mining regions of Peru, and on the prospects of using legal and regulatory means to hold transnational corporations responsible for human rights violations. So thank you very much for being here and for sharing your experiences. But I think what also sort of comes out from this panel, I was thinking about the program of the Bergen Exchanges, and it's so interesting that, the discussions throughout the week, actually, the rights of indigenous people sort of segue through the discussions throughout the week. So yesterday we were talking about corruption. On Thursday we're going to talk about natural resources. And so what we find is that, not only is the fact, so I want to put these thoughts out there, is not only is the fact that the indigenous people are placed against the dominant mainstream on questions of identity, land, representation, territory, and so on, but also we find in many countries, and possibly almost all the countries which have indigenous population, is that there is a significant overlap between the natural living spaces of indigenous people and natural resources. So for instance, in India, 40% of India's forested area falls within the area that is demarcated for the scheduled tribes. And of course, underneath the forests are the mineral resources. So 40% of India's coal production is done by Coal India Limited, which comes from, the forested area that falls in indigenous people's, squarely within indigenous people's land. And so that puts out the tension that many of you are sort of engaging with in your research is, with respect, whether it's with respect to mining or with respect to, other natural, resources like dams. When dams are built, which is a different kind of natural resource that is being exploited for various purposes, you again have displacement of indigenous peoples. And so it turns out that indigenous peoples are disproportionately displaced by many of these forces of development. And so that what brings me is that despite all its problems, at least in developing countries, it turns out that on the development discourse, within the larger development framework, we find that the development discourse always trumps the rights discourse. So even when you stand up for people's rights, when you go to the courts, if it is about development, the court is not going to, stall projects or things or it's not going to intervene. So within that frame, with all its flaws and all its issues, the rights discourse is somewhere the only sort of discourse, because the understanding of development, there is a very clear indigenous understanding of what development means, but that's not the hegemonic understanding, which the state, but also law and the courts really understand as, what development should be. So, and I think and so that's another thing I want to put to all the panelists. And finally, I think it was really interesting how you brought out, the sort of, when I started working on in this area, it was interesting to see the kind of suspicion with which the indigenous, not just the communities, but also the scholars would see interventions by non-indigenous scholars like me. And, because, like I said, on all of these understandings, it has taken, years to really fully comprehend what is meant by indigenous understandings of development, of law, of identity, and so on. And so, on the one hand, that tension is to be maintained, but on the other hand, it's also important to be critical in a way of some of the practices that you've also sort of brought out. And it's a very delicate balance that has to be maintained, because, and that brings us to, I think, another thing which is sort of unique to this panel, that we're an all-women's panel, and the one thing that we find in indigenous rights discussions, and especially I found that nobody was talking about women's rights within indigenous communities and within the practices that were unfolding. And finally, I just want to put on the table, and then I'm going to open it up to our panelists, the fact that, many of these, in some ways, indigenous peoples are really, at the really underprivileged. But with respect to some other communities, for instance, in India, like pastoralists, fishing communities, and so on, who also depend upon natural resources and so on, they do not even have legally recognized rights. So, I mean, the issue that we are talking about, indigenous understandings of development and so on, go beyond the rights of indigenous groups to other groups like pastoralists and fishing communities and so on, who may not have the same character or status of indigeneity, but may also still have the same issues. And so we can, in fact, broaden the debate. And as I mentioned, that, the issues that we are going to talk about resonate with all the themes yesterday about corruption, later about natural resources, so we can keep the indigenous rights discussion going. So why don't we start with you, Anna?
Hi, everyone. So thank you for the invitation first, and I would like to take advantage of this panel to tell you about some findings that I have found on my fieldwork that I just finished in Guatemala. And so it's exactly about these entanglements and political entanglements regarding the right to free, prior, and informed consultation and consent, that in the case of Guatemala, there is no law regarding this right, so everything is battled at the level of the high courts. And so the battle for the framing of the right to prior consultation is being contested by the two main actors that are interested to define this right, which are the indigenous peoples and the corporations. And So these are the main actors and players, and as Rachel was saying, they have very different interpretations and expectations about what the right to prior consultation should be. On the one hand, the indigenous peoples considered this right as one of many other tools, a legal one, to advance community governance, self-determination, and participation. And on the other side, you have the corporations that only interpret this as a mere procedural aspect of their economic interests. So we have there this contestation, ontological and epistemological, about what the right and the law should be about, and mainly the ILO 169, which is the only one that is being mobilized to pursue this defense of interests and claims. And what I have been noticing in the process of this judicialization is that there are much more actors and players behind the scenes, and that challenge the old, well, not the old, but this very nice theoretical framework about the transnational advocacy networks, that are these networks that advance in many levels rights for minorities, or transitional justice, or human rights in general for the marginalized. And that in the case of Guatemala, after 15 years of building transnational advocacy networks, the battle around the right of prior consultation is challenging these networks by the mobilization of very powerful and very important actors that are not only in the human rights sector, but mainly in the diplomatic sector, which in the case of Guatemala have a lot of power and define a lot of agendas. And so this is what my big question is: what to do when you have a long history of construction of white indigenous coalitions in order to advance rights, and on the other side you have huge corporation and diplomatic networks that are trying to do everything to protect the economic interests of corporations coming from all over the place to natural resource industry. And so that's my big question, and what to do when the right to prior consultation, that should be an indigenous right, is colonized by another kind of discourse which empties the indigenous potential there into mere procedural and corporation interest and discourse.
Thank you. Thank you, Anna. I think we'll go with all the panelists' comments and then have a larger discussion. So, Akanksha?
So, I wanted to talk about something which is contextualized with the overall theme that we have here, use of law for social change. So last year I was working with Narmada Bachao Andolan, which is one of the movements that was the first time World Bank withdrew from a project because of on-ground conflict. And there I saw the use of Right to Information Act by the on-ground activists in such an engaging way. And it was furthered by our own fieldwork at Land Rights Initiative, where we visited Jharkhand and we visited a lot of these on-ground leaders who have been using Right to Information Act productively to get the information from the government. It's a very powerful tool for the voiceless, marginalized sections to get the information from the government that they want. However, recently it was in the Parliament, Right to Information Act, Amendment Act 2019 was passed, which diluted the powers of the information officers and the central information officers, bringing them under the purview of the central government. And now, I just feel it is extremely sad that all these grassroots level activists, after using this powerful tool for so many years, in fact, the leading government, BJP, used it to unearth the scams that were under the Congress regime, and now it's being diluted, and I don't see how it will ever be empowered again, how the law will ever come back into force in the same way that it has been now, and how it affects the grassroots level activism in such a negative, a strongly negative way. So, yeah, I mean, this is an example of how on-ground activism led to the enactment of a powerful law which was later again disempowered when the government changes, and how it affects on-ground activism that has been going on for years and generations.
Do you want to speak a little bit about the issue of the gender dimensions of how indigenous representation works in the field research that we did in Jharkhand and some of the other states?
Not in Jharkhand, but one of the important things that I saw last year in my fieldwork was, so I visited Madhya Pradesh and Maharashtra both, the project affected families there. And in Maharashtra, there was a better engagement of the women in the movement as compared to Madhya Pradesh. And it was fascinating to see how in a movement that was led by a woman herself, Medha Patkar, and yet despite seeing her in such a powerful position, being the leader of the movement, and yet people in Madhya Pradesh were very reluctant from letting women participate in the movement in a much productive way because of the existing gender inequalities, the existing gender discrimination, and how it is so important to the movement that everyone from the family and not just the men are involved in the movement to make a stronger case for the social rights actualization. And well, it's interesting to see how the gender dimension plays out in the struggles.
Thank you, Akanksha. So now we have Natalia.
Yes, okay. So do you hear me? Well, okay. We have the big microphones. Okay, so thank you very much for having us here in the panel. I wanted to say that I really liked your lecture. It was really enlightening to me, and I just wanted to show you how my research and our findings kind of connects with the things you've already said, especially Rachel and Anna. My research, I've been conducting some research on indigenous people's rights in Colombia and in Bolivia recently, and I'm in the process of doing my fieldwork. So I will let you in. I want to share with you what I've found so far. So my interest in this discourse of the identification of indigenous people's rights is to see how if we say indigenous people's rights are political tools, as Rachel described very well, it means that indigenous peoples are political actors. From a political perspective, it means that they have kind of a strategy. And that strategy changes over time. But more specifically, and that's what's very interesting to me, is that it changes vis-a-vis their contradictors, So rights are just not like a law device in itself, but as a political tool, you have contradictors. And for indigenous people, it has changed over time. And we can say that, at least from the period Rachel was talking about, and to these days, we can talk about the states and the companies as contradictors, So that's what interests me the most. So what are the strategies, and how do if we say that indigenous rights are a platform for a political battle, how is it that they decide like the indigenous peoples decide what they're going to do. And so to understand how they decide what they're going to do, we need to understand the contradictors as well and how that game play out. So I would say that on the first, like, over time, we could say like there was like a first stage when they went out to the international realm and went for the juridification, like the codification, as you call it, and it happened in Guatemala, but it also happened in the 90s at different times in different other countries. For example, in Colombia with the Constitutional Assembly in 1991, and more recently in Bolivia. In 2009 specifically, But then we do know that laws are not enough. We need to implement them. And so there's like another round of these political battles, and that's the implementation battle that Ana is most expert on, like the decisions, judicial decisions and all that, And then what we see is that indigenous peoples are very powerful actors before the courts. In Colombia, they are less than 5% of the population, and still they got passed a very important decisions in the Constitutional Court. Of course, the Colombian Constitutional Court has been known for being an activist court, a progressive court, and so on and so forth. But they got that issue. And on the other side, at that time, if you see the records of extractive companies and even the Ministry of Energy, the Ministry of Transportation, and those kind of government agencies said, indigenous peoples on the right to prior consultation is like el palo en la rueda del desarrollo, like a stick in the wheel of development, And so that would happen, and they went to the court to battle that idea. But what I see now is that extractive companies, CEOs, and the government are on board with the discourse of the right to prior consultation, and that's very interesting. Actually, Rachel was telling me yesterday that she has seen in public information, like the enterprises want to protect the right to prior consultation, and there are business international standards that explain that. What I've seen when I've been talking to CEOs and companies' lawyers, what they say, it's like, yes, we love prior consultation. We just want to know how much does it cost, because they have just the financial problem, but they kind of like the prior consultation because it channels the conflict. It's an organized way to channel the conflict. So how do we go about that? So the response, what I found is that the response of indigenous peoples is, okay, maybe we don't want more regulation. So instead of going in that vernacularization path, like we want more and more and more laws, some indigenous peoples in Latin America, specifically in Colombia and Bolivia, are saying, no, we don't want more regulations. That's enough for law. So we want that space, but we want it as a political space. We don't want it as a legal space back. And so I think that it just fits very well in the story. And I'll let you know what I found more. But what I think is that really indigenous peoples have a political agency, and they play out specifically with companies and so forth. Thank you.
Natalia. I think it was really interesting what you're bringing out, which is also something I wanted to highlight, is that the indigenous people are not sort of the victims of the story in its fullest sense. There is a lot of agency and negotiation of these rules and these laws and these engagements, and when to engage and when to disengage and so on. And I think that what you said brought that out. But tying back with what Ana was saying, in your experience, is it the case that because what Ana was saying is that the companies look at this as a procedural thing, a thing that they have to go through. But from what you're saying is that it's also seen as not just a thing in the law that we have to comply with, but rather it makes sense to comply with it, because as you said, it channelizes the conflicts. In other words, is there buy-in into that system? Because from what you're saying, it seems to be more sort of, we have to do this as per the law, so we do it, but there's no real buy-in into the process.
Yes, so that's a very interesting question. I wouldn't say that for all like the engineers, the lawyers that comes from companies to attend prior consultation events, it's the same. Actually, I've found that they disagree a lot between them. It's different. For example, if you talk with a person that works in the construction sector, and if you talk with the person that works for the hydrocarbon sector. So that means different things for them. But I think indigenous peoples and courts have introduced the idea that prior consultation could be useful, at least. Not necessarily a good thing to do, as it is a useful thing to do, you know? And they found the way to adapt to it. And that's so interesting because, of course, they show it as right discourse. I'm not sure it's like the right discourse we are talking about or the indigenous peoples are talking about. Those are different contents, but they are all using the same language now. And that's why I think indigenous peoples are saying, okay, maybe not more laws, like let's stop there.
Right. Okay. And so the theme of conflict brings us directly into Angela's work. So Angela, please.
Yes, thank you very much. Yes, as Namita already said, I'm doing research on mining conflicts in Peru, and I focus specifically on corporate liability and on the use of law in social conflicts around transnational mining projects. So I analyzed two different mining conflicts. One is in the region of Cajamarca. It's the Yanacocha mine. Maybe some of you might know it. And the other one is a proposed mine in Piura, in the northern part of the country. So in a way, I examined the use of law by, on the one hand, social movements and local and national NGOs to hold transnational mining companies liable, and also to hold state actors liable because they are always or often involved in these cases of human rights violations. And on the other hand, I also... On the other hand, I also analyze cases in which corporate and state actors use criminal law in order to criminalize social movements. So there is also a backlash in the courts, and both sides are using criminal law in these social conflicts, and that is why these social conflicts have become lawfares. So in a way, I'm doing research on this topic that Rachel mentioned, the question in legal anthropology, whether law is an instrument of the elites, as the Komarovs have called it, or whether it could be a so-called weapon of the weak, as Julia Eckert called it. So it's in a way this debate. Here I would like to make 2 points. So my first point is that indigenous rights in my cases do not really play a role. So maybe I'm on the wrong panel, but it often happens to me that when I tell people that I'm doing research on mining conflicts in the highlands of Peru, they automatically think about indigenous struggles, but it's not the case in my study. So the movements I work with, they are mainly from small towns in the highlands, so from urban areas. They are what we would call mestizos, so they don't have this indigenous identity. And then there are others that also live in the rural area, but those people, they rather would underline their identity as campesinos, so as peasant, and not their identity as indigenous people. So indigenous rights is not really an issue for me. But what I would like to say, and that's my second point, rights are an issue for me. So, and rights play an important role in my cases. And that's why the activists that I work with, they heavily rely on rights. They claim to be Peruvian citizens, and as such, they claim to have rights or the same rights as, for example, people living on the coast or in Peru's capital, Lima. And this can be seen in the different court cases that I am analyzing. So on the one hand, there are the cases where the activists try to sue the corporate and state actors for these human rights violations. And in these processes, they claim to have a right to an investigation of the violations they suffered. They claim to have a right to due processes, a right to compensation or reparation, a right to know the truth, and ultimately a right to justice. So in practice, it's quite difficult to sue corporate and state actors in Peru, and this is for different reasons. But I argue that the claim to have a right to have rights, as Hannah Arendt called it, plays an important role for the activists. So, and this claim to have rights means that people continue to try to use legal means. Then, as I mentioned before, there are also discriminalization cases. So these are the cases where we can see the hegemonic force of law. And I have followed several of these court cases, and I analyze how social movements as a movement, but also how individuals face this threat of such criminalization. And what I could observe there, that rights or having rights again plays an important role. So while being criminalized, while having to go to court and being prosecuted, people insisted on their rights. They knew that the accusation against them were unfounded, so they knew that they are in the right and that they have rights. They participated in all the court hearings, they approached the judges and the institution as such with the necessary respect, and they followed the law and all the obligation inherent in criminal proceedings. And even their defense strategy was based in rights and law. So in the trials, the defense lawyer based their argumentation on the exact text of the criminal code. So they analyzed what is written in the law to show or to prove in a way that the activists had not committed any of the crimes they were accused of. And with this strategy, they were able to win some of the cases. So to sum up, I just wanted to say rights play an important role in my cases, and especially this right to have rights. And as Namita already said, there are other marginalized groups that also have rights, and I think it's important not to narrow down the discussion on indigenous peoples. Although it's very important, but there are other marginalized people that maybe do not fit this category, and that I think we should also take into account.
My one.
Oh, sorry.
This is technology. That's the last day of the exchanges. Thank you, Angela. I think you've justified why you are on the panel, and it is exactly right, because and I don't know about other countries, but indigeneity is also a fluid concept in a way, because in India, many communities continue to be recognized as scheduled tribes or indigenous groups. So it's a moving definition. So I've been shown that we have 5 minutes, but we started a few minutes late. So maybe there is time for just taking a few questions from the audience, and then maybe Rachel, if you would want to respond.
Mm-hmm. Someone else.
Is there anyone? Yes.
Camila.
Yeah, so this is the mic, just speak. Okay, so just to go to the point that Angela was saying, and also Natalia, I think this is a thing of what we count as an indigenous, and that is also a place of contestation. Cajamarca is a place that we have some kind of traditional justice systems, but still they don't define themselves as indigenous, because in the case of Peru, indigenous has been mainly on the Amazon, and the other people has been calling themselves on the highlands as peasants, because of discrimination. But if you ask to the people on Lima, they are going to say, all of these are indigenous. So it's also what we count as indigenous. We say, yeah, only 5% of the population in Colombia or Peru, or 6% are indigenous, but how we are counting indigenous is something that it's also really contested, and also because that is a big fight in some cases that you don't want to count a lot of population, because then you are going to provide this really narrow right to informed consent. So I think that is also a place to contest of what we are meaning by indigenous, how we are narrowing down, and what means this for people living in rural areas that, in this country. So, yeah.
Yes, in the back, Pilar.
Pilar? And
I think Pilar was probably before me, so.
Oh,
Okay. No, so I just want to thank all of you. I think this has been, Rachel, the lecture was just amazing and opened so many perspectives. And I also think that, so of course, one of the things I wanted to say in the introduction, and then I forgot, is that one of the reasons why we really, really wanted to have you as the keynote is that you're not only an academic, you're also so multifaceted experience as an expert, and that also goes to sort of you were talking also about the experience of filmmaking, but you worked with the activists, and but also this complex role of being of representing indigenous people and their conception of law in and presenting expert witness in different contexts. And I think that you have, and I think that this very deep and multifaceted experience is really so well reflected and brings out these ambivalences and ambiguities in a really good way. And I think to have all of your experiences talking to that is really good. So and really brings out the complexities of and why it is different. So I really liked, I didn't really think about that, because I was thinking about indigenous struggles as also being about changing the law, but this is a much more fundamental way of thinking about, but sort of that it challenges our categories in a very different way. It challenges our theoretical ways of thinking about rights struggles. And so thank you. This was really opened new perspectives in a very important way.
Hello. Thank you. I just want to echo Siri's comments that it was a fantastic lecture, so congratulations and thank you for that. And I want to, I'm not really sure what I want to ask, because you were talking about some very rich conceptual complexities, so let me try and find a way into how I want to frame, I think, what are questions. So, and it was fascinating to hear your encounter with this Mayan leader or analyst who, as I understand it, challenged the position that in this contraposition between state law and indigenous law, state law is judged for its normative aspirations, indigenous law for its practice. Actually, I think we do, maybe aside from when that conversation is happening between state and indigenous law, we do actually judge state law for its praxis in a lot of socio-legal studies. So then what's interesting for me is recognizing that hegemonic relationship and hierarchical relationship. What are the ways in which both normative content and praxis is being contested within indigenous community, indigenous space? And I think there one of the comments from the panel of what does agency look like? Because state law, indigenous law is always dynamic and changing and the object of contestation over time. So what do those internal debates look like and how is opposition voiced? I think that's where I'll leave it for now. Many thanks.
yeah. I think we should have at least one male intervention in the discussion.
Do you want to have them?
Yeah.
Should we have this?
We can have both, I think. Quickly, 30 seconds.
Thank you. Okay, so I would like to ask Rachel to expand, if you want, a little bit on the idea of indigenous law as a way of protecting indigenous survival, but also the survival of nature and the planet, as it is, like law as it is and as it should be for them, both from your ethnographic, but also legal understanding. And to Angela, I was thinking of the idea of maybe, like, if you and also your colleagues have seen how indigenous rights, for instance, the right to prior consultation, has been used also as a political tool by other groups, like farmer groups. Because I know in Colombia there is a discussion from farmers and other groups to be included as actors of prior consultation, because they have the same problems with consent and also the same kind of characteristics as a group. So if you have seen that as a political tool.
Yeah. So last comment, question.
Okay. Thanks. My name is Tomo Harada. I'm from NMBU. The two presenters talked about this notion of transnational advocacy network and contradictors, and I'm wondering if the contradictors exist within the IP communities. I know that in Russia, for example, we have one indigenous peoples group but has two representatives competing over representation, and they often have a very contradictory point of view. Some support states and some not. So I'm wondering if that's something, if there's something that you witness in your fieldwork. Thank you.
Our time for the panel is actually up, but Rachel, if you want to respond to all of that in 1 minute.
1 minute. Okay. Thank you. Yeah, it's a privilege to be on the panel with everybody else and kind of hear how they're taking forward many of the questions that we've been thinking about for a long time about the uses of law, the fetishes around consultation, the pros and cons of encoding identities in law, how that plays out, the tensions and the creative synergies between who's included in a particularly protected legal category and who might have many of exactly the same ecological, environmental, productive processes in the village down the road, but don't have that status, and kind of what happens in those conversations, what kinds of forms of legal activism, political activism are possible in those contexts, I think are really important questions. I also think that it's fundamental to look at maybe a bit less about how indigenous people use hegemonic forms of law and more at like how hegemonic law works, right? And particularly what the companies do. I remember being at a thing at Canning House where a lot of the CEOs do come and listen from time to time to the academics in London. About 15 or 20 years ago, and I gave a talk about ILO 169, and my boss at the time, who was an economist, said, you were sitting next to the CEO of X company, and the only thing that he wrote down was ILO 169 in his notes. So they've obviously been paying attention to it, but there's been so much good work done around the fetish of prior consultation, and I think the kind of comparative work that's being done is really important. But to Catalina's question, and maybe if I can just tie it briefly to the question around kind of contestation, but I was kind of thinking back to a lot of the earlier critiques that were made of, particularly of anthropologists, essentialization of Amazonian peoples as kind of, the environmental Indian, right? That whole body of literature and the kind of critiques around essentialization of indigenous peoples as inherently nature friendly, right? For want of a better shorthand, and how we're in a completely different stage of those conversations now. Right? I mean, we're facing every day more clearly a planetary and species extinction, and those conversations about other ways of stewarding the earth and the resources of the earth. Right? Where are we actually looking for inspiration and practice in those conversations? And I think that is also one of the reasons that so many younger activists look particularly to indigenous people's struggles. And And so this is the point that I'm trying to make about alternative ontologies and epistemologies without with being very aware of the dangers of essentialization, right? I'm not unaware of those debates and those pitfalls, but the kind of law as is and law as should be is about our relationship with beings other than other human beings. Right? It's about, and all forms of law are about that, but we happen to be in this particular stage of capitalist property-driven law, but there are other ways of thinking about stewardship, and I think that Indigenous activists, but also Indigenous legal scholars the world over are increasingly trying to have those conversations. I'm very struck by some of the work that's being done in Canada by people like Val Napoleon, who are kind of systematizing Gitxsan law, her law, and bringing those into the law faculties. So I'm going to stop there. There's more to be said about gender, but and contestation within, and I hope that we can carry that on in the next panel, or the next discussion. Thank you.
Thank you so much. And in like 20 seconds, if you want to respond to the questions, anybody on the panel, or we can continue the conversation in the coffee break.
We can continue.
Thank you so much to not just the panelists, Rachel, for your wonderful lecture and all your rich contributions, but to the audience for your patient listening and for your comments. Thank you so much. Yeah.
You can't wear your